You may wonder whether or not you should negotiate your divorce settlement on your own. Well, if you have assets which are not that significant, or things that you don't care about and don't mind your spouse having after the divorce, that really can't hurt you. One thing to remember is that once the divorce is final, what you have in your possession and what you have that's titled in your own name, like a vehicle or real estate, and what your spouse similarly has, will belong to that particular person, and you will not be able to make a claim later. That's one of the actually nice things about Pennsylvania law. If you divide up what you have before your divorce is final, what you have will be yours, and what your spouse will have will be your spouse's, and you won't be able to make claims against one another. Now, a divorce settlement is something that should be professionally prepared if it's going to divide up things after the divorce is final. For example, if someone's going to give somebody some money, say 5 years after the divorce is finished, you need to have that in a binding contractual form. If you do that yourself, it may not work. You need to have it done in such a way that if your spouse would not fulfill your spouse's obligations, you'll be able to take the settlement agreement into contract court and sue your spouse to attempt to make your spouse pay what the spouse is supposed to pay. Obviously, you can't get blood out of a stone. We don't have debtors' prisons anymore. So having someone agree to pay you money that you know will never be there is probably a waste of time. So if you choose to do your own agreement, you probably should at least discuss what you're settling with your lawyer, because, for example, a lot of people think that we should just divide our stuff up 50-50. And under our law, you can divide it up any way that you want. You can even divide it up 100% for one and 0 for the other if you desire. But as far as what the law would require in a contested divorce, our law essentially looks at dividing things up in an economically fair manner, giving more from the marital estate to the person who economically needs it more. The law would consider the incomes of the two parties, your financial future, what you may be inheriting in the not too distant future, and things like that. So dividing up 50-50 is something you're allowed to do, but you may be entitled to more or less than that. In many instances, a client might say to me, I'm the one who worked during the entire marriage. I paid for all of this, and I should have it all. Well, that doesn't work in court. When one works during a marriage, you are presumed to want to take care of your spouse, and the things you acquire on behalf of the marriage, not on behalf of your spouse. No matter how hard you work, that stuff becomes marital property and subject to division by the court in a fair manner. So, yes, you should probably negotiate this yourself, but before you finalize it, it's important to talk with an experienced lawyer just so you will know what the law would have done for you. And if you engage a lawyer to do your divorce, you should still run all that by the lawyer so he can give you that advice, or she can give you that advice, and you can decide for yourself whether or not you want to go forward with it and possibly ask for more from the spouse, or find out that you've actually negotiated a very good settlement for yourself. But getting advice before you sign anything you've done yourself is extremely important.